Okay, let's unpack this. Before we can even talk about things like guilt or motive or, criminal
The
intent,
whole mens rea side of things.
exactly, mens rea. Before all that, we have to start with something even more fundamental,
Yep.
right? The true bedrock of criminal accountability action.
hmm
Specifically, what actually counts as a criminal act? I mean, can you be punished for just thinking something? Or, on the flip side, for some involuntary movement you had absolutely no control over?
Yay! Yeah, that's the core question.
So the mission for this deep dive is really to nail down that foundation. We're going to dissect the Model Penal Code, specifically Section 2.01.
Right.
We need to define that required conduct element because under this code, liability just can't be based on thoughts alone or being in a certain state or, crucially, on involuntary movements.
And what's really helpful here, I think, is that the MPC gives us a pretty clear four-part way to analyze this. It helps us move beyond just gut feelings about what's an act. So we need to define the basic voluntary act, then figure out what the code says is involuntary, and then tackle the trickier areas when omissions, like not doing something, can lead to trouble. And finally, when just possession counts as an act.
That's a great roadmap. So let's start right at the beginning. The foundation. What's the main principle for all criminal liability under the Model Penal Code?
Okay, the foundational rule is in MPC Section 2.01, subsection 1. It's actually stated pretty simply. A person isn't guilty of an offense unless their liability is based on conduct that includes a voluntary act.
Okay, a voluntary act.
Or the other possibility is an omission failing to perform an act they were physically capable of doing. But the key thing for an action is that the conduct has to include a voluntary act. That's the first hurdle.
Just include one, not necessarily be entirely voluntary.
Exactly. If the prosecution can't show at least that minimal voluntary component in the overall conduct, well, their case just falls apart right there.
Okay, so if a voluntary act is the absolute requirement, this is where it gets philosophically interesting, right? How do we separate, a simple twitch, basic biology, from actual human choice? Does the MPC give us specifics on what doesn't count as voluntary?
It absolutely does, and that specificity is really important. Subsection 2 lists 4 specific categories of movements that are explicitly not voluntary acts. These are sometimes called 4 nots. Knowing these is critical.
4 knots, okay. What are they?
First, pretty straightforward. A reflex or convulsion. Pure physiology, totally beyond control.
Right, like a seizure.
Exactly. Second, any bodily movement that happens during unconsciousness or sleep.
Makes sense.
Third, conduct during hypnosis, or that results from a hypnotic suggestion. That one's a bit more debated in practice, but it's in the code. And fourth, this is the important catch-all, a bodily movement that otherwise is not a product of the effort or determination of the actor, either conscious or habitual. So it's something not willed.
That last one seems pretty broad. But I noticed things like sleep and hypnosis are listed separately from reflexes. Why pull those out specifically? Why not just let them fall under that last, not a product of effort clause? Is it because people might try to fake those states?
Well, that's a good question. I think listing them separately does a couple of things. First, it directly tackles some historical legal defenses where the line between, say, sleepwalking and just accidental movement got really blurry. The MPC basically says, look, we recognize these states generally negate control and intent.
Ah, okay. A clear signal.
Right. And second, the catch-all, that fourth one, seems more geared towards like pure accidents or external forces acting on the body. Someone bumps your arm, causing you to spill something. Sleepwalking or acting under hypnosis, while involuntary, are still your body's movements. So maybe they needed that specific exclusion to avoid confusion with, say, deeply ingrained habits that are considered voluntary, even if they feel automatic.
That's a helpful distinction. And the sleep exclusion. That leads us right into a really complex area, doesn't it? Testing the limits of involuntary when there might have been some voluntary action before the sleepwalking started.
Precisely. The timing matters.
Okay, let's analyze this hypothetical case.
Yeah.
First off, what are the legally dispositive facts? The ones that really matter here.
All right, the facts are these. We have a person with a known, documented history of severe violence committed while sleepwalking. It's a known issue for them.
Okay.
They decide to take a double dose of strong sleeping pills, and they know from past experience that this specific action often triggers these aggressive sleepwalking episodes.
Knowing the risk. Okay.
And critically, before going to sleep, they consciously choose to bring a weapon, let's say a knife, into their bedroom.
Oh, boy.
Then, while asleep and sleepwalking, they go into the next room and seriously injure someone with that knife.
Okay, so what's the core legal issue here?
The issue is Can the injury be legally based on a voluntary act? Given that the actual harmful movement, the stabbing, happened while the person was unconscious, which Section 2.012b explicitly says is not a voluntary act.
Right, that seems like a direct conflict. So what rule did the court apply to sort this out?
Well, they start with the main rules. 2.011, you need a voluntary act for liability. And 2.012b, movement during unconsciousness isn't voluntary. But the crucial piece comes from the commentary, the explanatory note to the code.
Ah, fine print.
Sort of. It clarifies that unconsciousness that was preceded by voluntary action might still lead to liability, but that liability is based on the earlier voluntary conduct.
Interesting. So how did the court connect the dots? What was the court's analysis? How did they bridge that gap between taking the pills earlier and the later involuntary stabbing?
The analysis basically shifts the time frame. It says, yes, the physical act of injuring the person happened during an involuntary state sleepwalking. That's clear from 2.012b. However, the defendant's overall conduct included voluntary acts before they fell asleep. Voluntarily taking the double dose, knowing the specific risk of violent sleepwalking. Voluntarily and consciously bringing the knife into the room.
Those earlier choices.
Exactly. The court reasoned that these earlier voluntary acts were reckless. They created the exact danger that came to pass. So the voluntary conduct set the stage. It caused the involuntary result.
So the MPC isn't just a snapshot of the harmful moment. It looks back for that preceding reckless voluntary choice that made the harm foreseeable. Okay? And the conclusion.
The conclusion is that liability can be imposed. But crucially, it's not technically based on the sleepwalking violence itself. It's based on the prior voluntary acts, taking the pills, getting the knife, which satisfy the code's requirement for some voluntary act in the chain of conduct leading to the harm.
That prior act carries the liability forward.
Precisely. You see similar logic in cases maybe involving someone who takes strong sedatives, known to cause impairment, and then decides to drive, leading to an accident while they're arguably unconscious or severely impaired. The driving itself might be impaired, but the decision to drive after taking the pills was voluntary.
Okay, that clarifies the act part. Yeah. So if we've established that criminal action needs to be voluntary, let's flip that. What about inaction? When can just failing to do something, an omission, actually be the basis for a criminal charge?
Right. This is another tricky area because generally the law doesn't force people to be good Samaritans, you know? We don't usually punish people for not acting.
There's no general duty to rescue, for instance.
Exactly. So the omission rule in MPC 2.013 is quite strict. It says liability cannot be based on an omission alone, just failing to act, unless one of two specific conditions is met. Only two.
Okay, what are they?
First, the omission is expressly made sufficient by the law that defines the offense. The statute itself says failing to do X is a crime. Second, a duty to perform the omitted act is otherwise imposed by law. This means there's some external legal obligation to act, coming from somewhere other than the specific criminal statute itself.
That second one seems key. It prevents, like you said, making everyone liable for everything they don't do. Can you give us some concrete examples of both of those conditions?
Sure. For the first one, where the law expressly criminalizes the omission, the classic example is failure to file an income tax return. The crime is the not filing, the omission itself, as defined by the tax code.
Got it. Simple enough.
The second condition, a duty otherwise imposed by law that often comes from specific relationships or situations. Think about parents' legal duty to care for their minor children. That duty exists under family law or specific statutes. So if a parent fails to provide necessary food or medical care, that omission can be criminal negligence or worse because the underlying legal duty to act was already there.
So the duty comes first, then the failure to meet it becomes the criminal omission.
Exactly. It could also be a contractual duty sometimes or a duty arising from voluntarily assuming care for someone.
Okay, that covers omissions.
Yeah.
Let's move to the fourth piece you mentioned, possession. This one feels a bit different because, possessing something is more like a state of being, isn't it?
Yeah.
Not always a clear action. How does the MPC make possession fit into the voluntary act requirement?
Yeah, it is a bit different, and it's super important because so many crimes involve possession, drugs, illegal weapons, stolen property. The code tackles this in 2.014.
Okay.
It says possession counts as an act for the purpose of this section if the possessor meets one of two conditions.
Two conditions again, what are they?
First one's straightforward. They knowingly procured or received the thing possessed. They bought it, stole it, someone handed it to them, and they took it. That's a clear voluntary action.
Right, an active acquisition.
But the second one is the really crucial nuance, especially for cases where someone just finds something. Possession is an act if they were aware of their control over the item for a sufficient period to have been able to terminate their possession.
Aware of control. So sufficient period to terminate. Can you unpack that?
Yeah, this basically links possession back to the idea of an omission. If you become aware that you are controlling something illegal, the law often imposes an implied duty to get rid of it, to terminate control reasonably quickly. If you know you have it, and you could get rid of it, but you don't for long enough, your failure to terminate becomes the basis for liability.
So the act is the failure to stop possessing it once you know about it and have a chance.
That's the idea behind that second prong.
Okay, let's definitely test that edge case. That aware of control part seems really important for listeners to grasp. Let's use another hypothetical. First, lay out the legally significant facts.
All right, imagine a person hiking, maybe off the main trail. They stumble upon a backpack hidden under a bush. Curiosity gets the better of them. They open it up, and inside they immediately see what are clearly illegal narcotics, maybe a large quantity.
Instant awareness.
Instant awareness. They feel sick, maybe panic a little, close the bag. They decide, okay, I'll just hike back to the trailhead and toss it in a public trash can later this afternoon. Get it away from here.
A plan to dispose of it, but not immediately.
Right. But an hour later, while still hiking back with the backpack, they get stopped by park rangers or police. The drugs are still in their control.
Okay, so what's the core legal issue now?
The issue is, did that hiker's awareness of the drugs, even though they just found them and didn't seek them out, combined with holding on to them for that hour, constitute a voluntary act of possession sufficient for criminal liability?
Right, they didn't get it voluntarily, but did they keep it voluntarily? What rule applies here?
It's section 2.014, again, specifically that second part. Possession is an act if the possessor was aware of their control for a sufficient period to have been able to terminate it. And like we said, this ties into omission. The law implies a duty to relinquish illegal items once you know you have them.
So how did the court, or how would a court, analyze that hour the hiker held onto the bag? What's the analysis?
The analysis would go like this. First, the hiker didn't knowingly procure or receive the drugs in the usual sense. They found them.
Okay, so prong one is out.
Right. But the moment they opened the bag and saw the contents, they became aware of their control. That's key. And crucially, at that moment, did they have the physical ability to terminate possession?
Well, yeah, they could have just dropped it right there and left it. Or maybe even called the authorities, depending on cell service.
Exactly. They had the awareness and they had the physical capability to end their control immediately. The decision to keep hiking with it for an hour, even with the intent to dispose of it later, represents a failure and omission to perform that implied duty to relinquish control promptly. They chose to extend their possession.
So that sufficient period doesn't have to be very long if termination is immediately possible.
Yeah.
And the conclusion.
The conclusion would likely be, yes, liability for possession is established. It's based not on the finding, but on the combination of sustained awareness and the omission to terminate control when they had a reasonable opportunity in this case, arguably an immediate opportunity to do so.
That really clarifies how possession works as an act.
Right, so we've gone through the 4 key parts of the Model Penal Code's approach to the basic conduct requirement, the actus reus. We've covered the voluntary act, what's involuntary, omissions, and possession. So, putting it all together, what does this mean for you, the listener, when you're trying to analyze a potential crime? How do you break it down? Here's a kind of diagnostic checklist based on MPC 2.01 that you can mentally run through.
Okay, a practical framework. Let's hear it.
Step 1, identify the conduct. What did the defendant actually do or not do? Was it an act, a physical movement, or was it an omission, a failure to act?
Act or omission, got it.
Step 2, test for voluntariness. If it was an act, ask, was it a product of the actor's own effort or determination? Conscious or even habitual effort counts. If not, does it fit one of those 4 specific involuntary categories we talked about, reflex, sleep, hypnosis, or that catch-all, not a product of effort?
Check if it's excused as involuntary.
Okay. Step 3, check for prior voluntary acts. This is that nuance from the sleepwalking case. If the specific harmful movement was involuntary, look back immediately before it. Was there a voluntary act that recklessly created the dangerous situation? If yes, liability can attach to that prior act.
The look-back step. Crucial.
Step 4, analyze omissions. If the issue is a failure to act, ask those 2 key questions. Does the law defining the crime expressly say the omission is enough? Or was there some otherwise imposed legal duty to act from a relationship, a contract, a statute?
Duty or express statute. Right.
And finally, step 5. Evaluate possession. If the crime is possession, hit those 2 prongs. Did the defendant knowingly procure or receive it? That's prong 1. Or were they simply aware of their control over it for a sufficient period to have been able to terminate that control? If yes to either, the act requirement for possession is met.
That's a really clear step-by-step way to approach it. Identify, test voluntariness, check prior acts, analyze omissions, evaluate possession. It really structures the whole analysis of the physical part of a crime.
Exactly. It's the foundation you build the rest of the case on.
It absolutely is. And thinking about this framework, especially that definition of a voluntary act needing to be a product of effort or determination, either conscious or habitual, it raises a final interesting question for you, the listener, to maybe think about. How much of our everyday routine, almost automatic behavior, like, driving the same commute every single day while your mind is a million miles away, or mindlessly scrolling through your phone, or even just walking down the street, how much of that truly meets the legal standard of effort or determination? And where does that kind of habitual, barely conscious action potentially blur into something closer to the involuntary, even if it doesn't fit neatly into reflex or sleep? It's something to consider the next time you find yourself moving through the world sort of on autopilot. Where does the law draw that line?